day and welcome to this week's edition of Strictly Legal on WESN Content Capital. I am your host, Rondell, Donawa, attorney at law. Once again, I'm happy to be here. Once again, I'm happy to bring the law and you. And of course, you can stream us on WESN Content Capital, all social media and traditional media platforms, including Strictly Legal with RondellDonawa.com. That is our podcast and our YouTube channel. And this week, we have another senior counsel by his name, John Heath. But of course, before we get into that, we now have our segment, Legal Lingo. Now, our legal lingo for today is reasonable doubt. Now, what is reasonable doubt? The doubt that prevents one from being firmly convinced of a defendant's guilt or the belief that there is a real possibility that a defendant is not guilty. In criminal cases, of course, beyond a reasonable doubt is the standard of proof used by a jury to determine whether a criminal defendant is guilty. And of course, let's span back to our case example. Now, in a criminal trial, a man named Alex is accused of theft. The prosecution presents evidence, but some key details remain unclear. There is no direct witness to the crime and security footage is blurry, making it very hard to identify the suspect. Now, the defense argued that Alex was elsewhere at the time of the incident and provides an alibi. As the jury deliberates, some jurors express uncertainty, noting gaps in the evidence and the possibility that someone else could have committed this crime. They are not fully convinced of Alex's guilt and believe there might be a chance he is innocent. The lingering uncertainty leads them to conclude that the prosecution has not provided its case beyond a reasonable doubt, ultimately resulting in a verdict not guilty. So there's an example of beyond a reasonable doubt. This was Legal Lingo. We'll be right back with more.
Come travel with us as we explore Diwali across the globe. Diwali is celebrated in many countries worldwide, but do you know the traditions and practices of each nation? From Guyana to Australia, WESN presents Diwali Passport,
October 9th to October 30th, with replays on October 31st.
It's Diwali Passport, a WESN exclusive.
And we are back on Strictly Legal on WESN Content Capital. And as I said before, we have a very esteemed guest. His name is Mr. John Heath. But before we get into the topic, of course, our topic for today is Caught in the Dragnet, Understanding Felony Murder and Constructive Possession. And Mr. Heath, of course, he is now a senior counsel. I've had the opportunity to train under him in Trinity Chambers when I was doing my in-service. And I must say congratulations to him, of course, on his conferment of senior counsel. Now, he was called to the bar on the 28th of October 2005. He joined the Trinity Chambers, who head of chambers at the time was the late Desmond Alum SC. He joined the criminal bar executive in 2006 and remained a part of the executive to this day. within a couple, within his private sector practice. He diversified his law practice, included civil, public, employment, industrial relations, and constitutional law. He appears before the court primarily as an advocate attorney. He was called to the bar in Greendot in 2009, and in 2014, together with his colleagues, Mr. Rajiv Prasad and Lionel Luku, he formed Alum Chambers, which presently house a total of 24 attorneys. That reminds me of Trinity Chambers back in the day. And on the 8th of May 2023, he was appointed in the rank of Silk Senior Counsel, and he is a household name in our jurisprudence. And I would like to welcome again on set Mr. John Heath.
Thank you so much, sir.
Yeah, it's good day, Senior Counsel.
Yes. Thank you for having me.
Yes, no problem. And of course, you know, our discussion today is about felony murder. I mean, I don't think many people understand the concept of felony murder. I mean, when you think felony murder, you think a felony that is a term that is used in the United States,
yes.
Right?
Yes.
So really and truly, this really is about understanding what is felony murder, and of course, what is known as the deem provisions, whereby someone is innocent until proven guilty. But of course, you're the expert. So tell us, what is felony murder in that context?
Yes, well, perhaps the best place to start with respect to understanding felony murder is to state how it appears in our legislation under the Criminal Law Act, right? So I'll just read out the definition and then I'll just go into explain its operation. So under Section 2A of the Criminal Law Act, it says, where a person embarks upon the commission of an arrestable offense involving violence, and someone is killed in the course of furtherance of that offense or any other arrestable offense involving violence, he and all other persons engaged in the course of furtherance of the commission of that arrestable offense or any other arrestable offense involving violence are liable to be convicted of murder, even if the killing was done without intent or to cause grievous bodily harm. Now, the distinction with respect to felony murder and what we refer to as classic murder is really the main salient difference is intention, right? Because in specific classic type murder, there must be a specific intention, which forms the mental, or what we know as the mens rea. In felony murder construct, the intention is not an element. If it was in the commission of an arrestable offense, and essentially an arrestable offense is an offense for which you could be arrested without warrant, which carries a term of imprisonment of over 5 years. So for instance, robbery with aggravation, arrestable offense. If in the commission of that offense, there's violence and someone is killed, you would be liable for murder. Whether you intended or not, it does not matter, all right? And I will come later to explain what I see as a sort of dilemma with respect to a factual matrix which can be mounted on the basis of felony murder or on the basis of joint enterprise. There being no difference with the facts, but it's the exclusive purview of the Office of the Director of Public Prosecutions to say on which basis the prosecution will be mounting the charge, the prosecution. Yeah. Perhaps the best place to start is a case called Nimrod Miguel, because that case sort of brought a sort of watershed moment in our jurisdiction. Not by intention, but by design, meaning that what the ruling that came out of there created a sort of categorization for murder in our jurisdiction, yeah. Prior to which the only sentence for murder was death. Now, there had been challenges to the mandatory nature of the death penalty before Nimrod Miguel. But even though the courts, the Privy Council, had stated that the death penalty was unconstitutional and really was cruel and unusual punishment, specific intent murder was nevertheless saved and as existing law, and so they could not touch it. What happened in Nimrod Miguel, the case really was mounted on alternative basis. Joint enterprise as well as felony murder.
Can you just explain, of course we'll be speaking about joint enterprise, but what exactly is considered joint enterprise for the purpose of an arrestable offense?
Right. So 2 or more people embark upon an offense, so let's say robbery with aggravation, right? And let's say they go to rob a bank. One is outside on the lookout and one is inside. Inside, there's a fight, takes place, he has a gun, the perpetrator has a gun, a person is killed. They're both liable on the basis of joint enterprise for the murder, notwithstanding one was just outside waiting in the vehicle, all right? It used to be, prior to a case called Jogi, that the foreseeability test was used. So if though you were in the car outside, you know that your confederate went inside there with a gun and something could play off, well then you were equally liable for the murder. Since Jogi, however, intention is brought in, and in the secondary, you must find that he also intended, and foreseeability is just a factor that the court can use to see whether or not the intention was born in the person who's outside. Yeah. So the principal is the one who is inside. Now, why I had alluded to earlier on, the dilemma is that both felony murder and joint enterprise can be one and the same, because in that exact same scenario that I've described, you can also bring it for felony murder, right? So in Nimrod Miguel, what had happened was the appellant, Nimrod Miguel, and 4 other persons decided to rob someone of their car. They did, violence was used, the person died. The judge in that case summed up the case on the basis of joint enterprise and felony murder. However, when the jury came back with their verdict, the judge did not ascertain upon which basis the jury had found them guilty. So they appealed.
And when you say on what basis they found them not guilty?
Either on the joint enterprise or on the felony murder.
Okay.
Right?
Yeah.
And why that was important, because even though they had lost the appeal against conviction and sentence at the local court, they appealed on the basis of sentence. And what the Privy Council pronounced was that though specific intent murder was saved as existing law, because felony murder construct came in under the Criminal Law Act, that was not saved law, and therefore the mandatory imposition of the death penalty in cases of felony murder was unconstitutional with respect to sections 4A and 5.2b of the Constitution. What that meant is that for the first time, persons who were found guilty of murder on the basis of felony murder were entitled to have a sentencing hearing. It was not mandatory that death will be the sentence. And so that, why I say that created a sort of watershed moment in our jurisdiction, is because for the first time you had persons en masse pleading guilty to murder. Now, coincidentally,
but why? I mean, because what? Is it that the offense? Is it that the sentence will be less?
Yes.
Significantly less than if it's. I mean, obviously, if you apply the death penalty is that.
So so the sentence would not necessarily be death, right? But it so happened in our jurisdiction, because there's no constitutional right to a speedy trial. You've had persons, by the time the Privy Council decision and Miguel came out, languishing in prison for years, awaiting trial. So when that Miguel decision came out, they realized, well, look, if my case is really the worst of the worst, and I don't think I'm going to get a death sentence, which is for the worst of the worst crimes in terms of killings, unlawful killings. You had persons coming and pleading guilty. They know they would get a third of their sentence, and they would also know that they would also get all the time spent on remand awaiting trial taken off. So if you were there for, let's say, 15 years, and you got a sentence of 30, you take a third of that, that's 10 come off, and then you're there for 15 years, the next 15, 5, and if you were good character, you get, so you literally had 3 years to do 2, because, a jail year is 8 months. So all of a sudden, persons were seeing a way out of the prison system. And I don't have the statistics, but I mean, I'm sure that it must be in the hundreds with respect to persons who took this avenue because of what had the ruling in Nimrod Miguel. All right? So,
and this was sometime in 2011.
Yes, right? And so I think Nicholas Aguilera was the first case in which they pleaded guilty and which the sentencing guidelines came down with respect to that. But there have been, it has to be in the hundreds with respect to persons who have availed themselves. The dilemma, in my view, is that
and are they still availing themselves of that particular aspect?
Of course. So, and the way you have to do it is that if you feel on the evidence that there is the basis for felony murder to be applied to the case, you write to the DPP and you ask for him to agree, by way of plea agreement, that your client plead guilty to murder on the basis of the felony murder rule. And that will, once that is settled, then the judge will know it's a sentencing exercise from that point on. Now, the dilemma that comes in is that if you as a counsel representing your client sees that the evidence has felony murder, there's really nothing you can do because the exclusive purview of mounting the case and basis for mounting the case is with the Director of Public Prosecutions. So if you write to the Director of Public Prosecutions and he says, I don't see it, I am proceeding on specific intent, or I'm proceeding on the basis of joint enterprise, in which intention is a main element, you really have no choice in that. You have to go ahead. Now,
but then that is where the defense now will seek to change the charge?
Well, we can't change the charge. What you will hope to do is to bring it out in the evidence during the course of the case,
right,
and intimate to the trial judge that, look, this is really a case for felony murder, and you ought, in this circumstance, to direct the jury on that. Yeah. And I'll tell you why that is important, because as criminal attorneys who are representing persons who are charged with murder, the first thing on our mind, well, let me not say it, first thing on my mind is what can I do to get this noose away from this man's neck? And there's a number of things can happen. I could go to trial and try to get as best as I could the jury to return a verdict of not guilty or a judge alone. Or I could try to plea it to a lesser charge, maybe manslaughter, on the basis of the provocation or diminished responsibility. Mm-hmm. Or since Nimrod Miguel asked for felony murder. Now, this issue sort of came to a head in a case in which I represented an accused in a court of appeal called Jason Huston. Now, I didn't appreciate it at the time why the DPP himself came personally to argue that appeal, right? But I have since appreciated it because it was important for the DPP to maintain the exclusive domain of how a case is mounted. And in that case, essentially, the DPP was saying, well, the judge is not wrong to not sum up on felony murder because we didn't bring our case on that.
So
right?
what was the facts of that particular
right.
case
so yes.
to get us to that point?
Yes. So the facts in that case is Jason Huston went to a house. A female was there at the time. He opened the door. He asked if her husband was there. She said no. He then proceeded into the house. She was stabbed up multiple times. In his statement to the police, he had indicated when I did that, I went upstairs, I saw her wallet, and I took $1,500. Independent of what he had stated in his statement, one of her family members would have said, I knew she took out some money in her wallet, and the wallet was missing. So we're saying that's the commission, arrestable offense, violence is used, right? My simple point was, notwithstanding what the prosecution wants and what the defense wants, because sometimes we want different things based on the persons that we represent, right? And the judge has to rise above that. And my simple point was, if you see on evidence it comes out, then I think you're bound and mandated to put it to the jury. The DPP was not of that view. I mean, and all respect to Senior Counsel Mr. Gaspard. He is protecting his domain in terms of mounting a prosecution and on what basis, right? I'm simply saying that that's fine, but if evidence speaks out during the case, then a court must address that. Ultimately, the court, on a majority decision, allowed the appeal, and they found that the judge ought to have put felony murder, and he was therefore sent back for resentencing. Now, it's still hanging in the balance because that appeal was dealt with the most senior judges at the time, and still are, Justice Musai, Justice Suhan. Justice Suhan is no longer there, and Justice Mohammed, right? Very well-respected criminal justice of appeal. And Justice Mohammed wrote the dissenting judgment. So, of course, in deference to Justice of Appeal, Mr. Mohammed, it's something that is still live and has to be looked at. And because no doubt the DPP is going to be of a view, certainly if I am representing someone and felony murder is there with respect as evidence, I'm always going to ask that the judge sum it up on the basis of the felony murder rule. But the dilemma is this. So, for instance, I alluded to that in Nimrod Miguel, it was put on alternative basis, right? Joint enterprise and felony murder, really the essential element of intention has to be proven in respect of joint enterprise. But it's of no moment, whether or not you intended when you went to rob, you intended for anybody to get hurt, it does not matter.
But then what's the difference in terms of, okay, there was no intention. So, I mean, you have the act, you have the intention in order to create the offense of murder, the elements of murder. Yeah. So what is the difference between the felony murder and manslaughter then? If there was no intention to commit the murderous act.
Yes. So with respect to manslaughter, there is no intention to kill or to cause grievous bodily harm, right? So, for instance, in a case I was called Sunil Singh, he had stated to the police, I thought we were going to beat him up. And the police in the interview said, well, when you say beat up, what you meant? Mm-hmm. I thought we were just going to hit him a couple slap. Now, if that is believed, then a couple slap is neither intention to kill or to cause grievous bodily harm. And so therefore, if it's lower than that, it's not a case of murder, it's a case of manslaughter, right? Because murder is intention to kill or to cause grievous bodily harm, right? And in that case, even though his defense, and this is the next dilemma, sometimes your defense will run contrary to the principle of law. His defense of that was denial. But I'm saying, notwithstanding that, if there is evidence, and there was evidence, because he told the police in his statement, then that was it was something that the jury ought to have been addressed on and directed their attention to, that if they believed in his statement that when he was going there with his confederate, it was just really to slap up the man, then that's not an intention to form murder, right? In joint enterprise, you have the intention either to kill or to cause grievous bodily harm, right, from the enterprise that you have embarked upon. That very same enterprise you have embarked upon, if it's felony murder, the prosecution does not have to prove you intended anything. All they have to do is to prove that there was a commission of an arrestable offense in which violence occurred and it resulted in death. And it specifically says your intention is of no moment, right? And I'm saying, if you have to go to court, and this is one of the problems I had when we were doing preliminary inquiries, because my view is that someone ought to know the case that they have to face. And part of knowing the case is knowing what principle are you basing it on. And I used to find, when we used to have what we call preliminary inquiries, now replaced by the sufficiency hearings, I used to have to pull proverbial teeth to try to get the prosecution to say, at that stage, at the preliminary inquiry stage, this case is being mounted on joint enterprise, felony murder, X, Y, and Z. And it's important because you need to know how to mount your defense. Yeah. Whether or not I have to address the issue of intention if it's joint enterprise, or whether intention is not an issue because it's felony murder, it's felony murder construct. And that, as I said, continues to be the dilemma. It was dressed somewhat in Hostin, and the majority seemed to suggest, look, it's something that the court, the judge ought to put to the jury, right? Because there's a big difference with respect to getting a term of years and getting the death penalty read against you, right? Because generally speaking, and it has only happened probably now twice, persons don't plead guilty to specific intent murder. I saw it happen, as I read in the papers that it happened on Monday, but even reading that, the judge would have...
And specific intent murder, meaning that there was an intention to commit the act? Or,
yes, and then the only penalty is death.
Yeah.
Because the thinking was that you cannot plead guilty to murder because you're going to die, right? But I understand in that case the judge was very careful, and the accused man was willing to do that since last year, and they've taken all the precautions, let him see a psychologist so that he understands, and he seems to be dead set on pleading guilty to murder, all right? And I do see in that case, the judge is also calling for legislation to deal with the categorization of murder, right? So that the death penalty is really reserved in the rarest cases for the worst of the worst, right? And you have...
I recall even that categorization of murder, senior counsel Khan would have spoken on that and advocated for that,
right? So that, but just to bring it back to felony murder, by design, felony murder sort of created a characterization because it allows for a determinate sentence in cases of murder, which did not exist before. So that was not Parliament doing that, but that's what the highest court in our land saying, no, it's unconstitutional. It's in cases of felony murder, it's not mandatory, and therefore it's not that the judge can't sentence someone in felony murder to death, but it would seem to have to be the worst of the worst.
It's that the judge, you're saying that the judge can sentence someone to death?
Yes,
in felony murder?
Yes. Okay. But it's not mandatory as with specific intent. That has been preserved because it's existing law by the Savings Law Clause, but because felony murder came in under legislation after our Constitution, that was not saved. So that I suppose in the worst of the worst cases, you can get sentenced in felony murder to death. But it hasn't happened yet, but it is one of these sentences that can be passed.
Now, due to the appeal, you were stating that that's in the Nimrod matter, that there has been a floodgate of persons now basically pleading guilty.
Yes.
Now, that is pleading guilty for cases that are currently before the courts. But what about if they were not charged for felony murder and they were charged for murder based on the DPP's advice?
You're not charged for felony murder or specific. You're charged for murder, and then the facts will speak, or the prosecution will indicate what is the basis. They say, look, this is a case of classic murder. The man went into the house, he pulled a gun, he shoot, he kill. He didn't come to commit a crime, he didn't rob anybody. He had motive, it was an ex-lover, whatever. It have no fit for felony murder there, it's specific intent, right? So there's no gray area in circumstances like that. The guy who again wants to plead or who has indicated he's going to plead, it seemed that was the circumstances. He went to a bar, he killed somebody because they had done something to a friend of his, and there's no room, it would seem. So the DPP would not, for just taking its sake, take a felony murder because it didn't arise on the facts, right? I'm saying that there's sometimes a gray area, as in the case of Hostin, because it was just a small part in the interview. He said, well, I went and I take all the money from it. And the witness said, just mention it kind of cursory, right? But so there's a gray area in which there may not be an agreement, or it may not be so clear. And then I'm saying to break that tie, meaning the tie between the defense and the prosecution, I'm saying the judge is the person to say, yeah, I don't think it arises, or it arises. And that's what happened in Hostin.
I think we've covered the felony murder
construct. Yes.
Construct. So let's turn to the constructive possession element. Can you just give
sure. Well, constructive possession in terms of a legal construct really is a sort of fiction, a legal fiction, in that you are in possession. For instance, if you have a television in your home, You're not there right now. You're not home with the television. It's not within your physical reach and control. You have the remote. Notwithstanding that, you are in constructive possession of it. It is yours. You bought it. You can go home. You can open your door. You could turn it on. You could turn it off, right? So there's an element of control. Where I say it's a sort of legal fiction is because actual possession, the possession can be of two types, actual or constructive. Actual possession is when it's on your person, within your reach, in your pocket, in a purse, right within your control, physical control. Yeah. Constructive possession kind of creates the legal fiction that it's in your physical control, though I can't see a TV on you now, but I'm saying wherever it is, it's yours, you have control over it, right? Okay. So that is the dilemma. Now again, in terms of the law of constructive possession, actual possession, there is an interplay with what we refer to as the deeming provision, which itself creates a fiction in that you are deemed, if I find that you were in possession of it, you're deemed to know it's there.
And we're saying in possession of
drugs. Drugs. Yeah, drugs.
Okay, so if you're using drugs, right? Okay.
So let me try and draw some examples from it. So for instance, drugs are found in a room at your house. The room is yours. Nobody else sleeps there. All your clothes, everything. You are deemed to know it's there, right? But in any case in which the deeming provision is used, the prosecution must prove occupation, possession, and control. Because again, there are circumstances. It might be my room, but the circumstances don't speak to me being in possession. I'll give you an example. In Canadian cases, there's a series of Canadian cases which are used in our jurisdiction to finally come to a point in our local case called Lakshmi Bharat, right? But in R versus Gunhing, I think it is, Gunying, the appellant was out of Ontario for a couple of days. In his room was found some opium. In his room at the time was his wife and another man who was not resident there but was resident within Ontario. The court nevertheless found it was his room, charged him, and he was convicted, right? But on appeal, the court really laid down the test. Say it could not be that Parliament intended that in that circumstance, the man could be in constructive occupation, meaning if or not they are still there, right? And the circumstances were such that you could not rule out that the drugs was there, placed there by persons who were in the room, right? Without his knowledge and or consent, right? So there must be, as our local court came to say in the case of Lakshmi Bharat, and prior to Lakshmi Bharat, we had a series of cases started with Mantur Ramdani, Thomas and Garcia, Ramdas cases, in which the courts were haggling with what is really occupation. And for instance, in Mantur Ramdani, they seem to have given it a wider definition. So occupies does not mean that because you're an occupant. Because I'm inside this room now, I'm occupying its space, I don't qualify to be occupying here in the legal sense. I have no element of control inside here. I can't go and interfere with all these knobs. I don't have the key for the door. I don't have anything. So I certainly don't have any control. They simply say, so in Lakshmi Bharat, they tied it down to say, look.
Can you just explain the facts so that persons get context?
Yes.
In the Lakshmi Bharat case?
Yeah, so Lakshmi Bharat was essentially a case in which Lakshmi Bharat was the front seat passenger. Drugs were found in the back seat. There was a back seat passenger and there was the driver. Upon arrest, Lakshmi Bharat said that she didn't know anything about what was contained in there, right? So coming out of the cases, it defined and refined, that mere presence in a vehicle where your presence is serendipitous, without more, you haven't done anything, you're just there. Persons can't be deemed to be an occupier in that sense, because they have no evidence of any element of control or ownership of the vehicle. And in those circumstances, such a person will not be found guilty. Because it used to be before that the police taking on everybody
Yeah,
in the house,
exactly,
everybody going down.
That is what I was about
everybody
to say.
in the car. If it found in the trunk, everybody going down, everybody getting charged.
But that's the same thing that's happening now, not so?
Well, it's happening now, but a lot of people are getting off, and a lot of people are bringing in malicious prosecution matters, right, before the court. Because, as I say, the law, if you don't have anything more to rise above the person's mere presence, inevitably it seems that they're going to be found not guilty, right? You can, in circumstances like that, if you have additional circumstances, find, for instance, the person, or let me use and we'll tie it back to constructive possession. Yeah. In the case of, Canadian case of Bruno, Aaron Bruno, the police went to the vehicle, and in the back seat, they saw someone trying to hide something. They opened it, they found drugs in it. The driver of the vehicle was then coming back to the vehicle. He had a knapsack. They realized he runs off. They chased him. He flung the bag, right? When they found him, he's not in actual possession of the bag. So you can't get him on actual possession. You need to show that he was nevertheless in constructive possession of the bag. Fortunately, in that case for them, for the prosecution, inside the bag were packets, and when they did the DNA, they found his fingerprints on the packet. So that was used to show, notwithstanding we didn't find the drugs on him, he nevertheless was in constructive possession, or the court had the evidence that he was in constructive possession of the bag. In the case of Peter Coltes, which I did the appeal, the evidence was that he was in a boat. The Coast Guard gave chase, and they flung the marijuana into the sea. Now, in his first case, they used the deeming provision to say, look, it was found, even though it was found in the sea, the deeming provision applied, because it went to the Court of Appeal. He got off on the Court of Appeal in that instance and had the retrial and was found guilty, and that's when I represented him at the Court of Appeal. But when I went back again, I was saying, no, the Court of Appeal is wrong. It was not found in. Literal interpretation, right? The court agreed with me with respect to it must be found in. So if you have premises found in, a vehicle, a place, a vessel, it must be found in.
So now we're basically arguing what is the layman, what is the definition of words.
Yeah, well, that's what we do.
And
that's what we do.
interpretation, of course.
So in that case, even though my then good colleague, Mr. Busby, was arguing that found means discover. So even though it was discovered in the sea, deeming provision could still apply. The court said, well, no, you can't do that. But nevertheless, he would have been, from the evidence of the chase of seeing them fling the bag, be in constructive possession of what he threw into the sea, right? And therefore, nevertheless, even though the judge would have erred, but the judge in that case only erred because the Court of Appeal had stated that the deeming provision ought to be used. Now, what is important with respect to when the deeming provision applies is that there is a reverse burden. Generally, in a criminal trial, the accused person doesn't have to prove anything, and in fact, it remains silent. Yeah. However, in deeming provisions such as this, there's a reverse burden, so that if the court finds there is possession, the accused person now has to give evidence to show on a balance of probabilities, lower standard than the reasonable doubt, that it was not there with his knowledge and or consent. And that is important because, so bearing in mind, in any case in which the deeming provision for drugs is applicable, you must have occupation, possession, or control. These are the elements that they have to show, right? Because it's not in every case which on the face of it, it seems that a thing was found in which the person is an occupier that you will charge. So for instance, in the New South Wales case of Ep.88, the drugs were found in a couch, underneath a couch, but there were 6 persons in the house at the time. That area is a common area and will be traversed by many people. So the appellant, they charged, the appellant was convicted, but it was overturned because they could not rule out the possibility in the circumstances of that case, notwithstanding he lived there and he'd occupied there, that the circumstances of that case, that it could not belong to anybody, any of the other 6 persons. So I mean, I have seen it happen in cases in which you're just sitting down that are involving drugs where the person is not giving evidence, and you're saying, but it seems that the prosecution have discharged their burden in proving that the thing was there. And if your person does not, in those circumstances, give evidence, where the court finds that the prosecution has proved their case, then inevitably you're going to be found guilty, because the burden shifts on you and you would have offered no evidence. And remember, it's a legal burden. It's a legal burden on a balance of probability, as opposed to an evidential burden by just raising the issue. And you can't not give evidence and satisfy your legal burden on a balance of probabilities. All right? So that is the dynamic with respect to constructive possession and the deeming provision. Right?
So what about what evidence? So, I mean, going back to the case where drugs were found in a vehicle, but what evidence is necessary to link a specific individual to an item, particularly in that shared space?
Right. So that's what I'm saying. If you have some element of possession and control. So, for instance, that's why the driver, and I mean, sometimes persons come to us, I get charged with 3 other persons, and you just close your eye and say, where were you in the vehicle? And if you say, look, well, I was in the front, and because the drugs were found in the back, then you kind of breathe. But if you say, well, I was the driver, you all automatically start to think, well, okay, water more than flowers. So, for instance, if the drugs is in the trunk, if the vehicle is in the driver's name, it's his vehicle, there's no evidence to suggest that this vehicle was anywhere else. He has control over that vehicle.
Yeah.
So that's where the deeming provision provides. If you're deemed to know it's there, and we have proven, because you're the owner, we put in the certificate of ownership, we put in the fact that we've seen you surveillance using this vehicle for the last week, coming home and to and fro, element of control, and no one else, that person, the driver, it would seem in those circumstances is going to be in trouble, right? As opposed to someone who is just sitting in the front. Because and why I'm saying the deeming provision is a fiction, you can never know what's in a man's mind.
Correct.
But if I'm just sitting without more in the front seat, then there's no evidence against me with respect to the element that I knew. And I don't control this vehicle, I don't own this vehicle, and therefore the state's case, they will always have a problem of such a person. And that's why, coming out of the Lakshmi Bharat case, one of the principles of serendipitous presence, just mere presence alone, will never be enough, right? So that is the dynamics of the difficulty, because we have moved away from the carry everybody down, even though it still happens, right?
Yeah.
But we have certainly moved away from that, and the cases suggest that occupies has a narrow meaning to it. But even in that sense, you have to look at the particular circumstances of the case, right? So the gun case that I told you about, he was away. He was not home at the time. His wife and another man was there. But nevertheless, they charged him, right? I just finished a case, I mean, that might go elsewhere, but in which a client was charged for possession of guns and drugs in his house. Well, 3 of them, right? And they were deemed because they were all occupiers. They didn't, that was the evidence. Yeah, that's where we live, right? So fortunately for them, it was a very big raid. Lots of items were found all over in the neighborhood. And we were saying that their house was simply used as a repository to bring everything and store it there. And the police went on their social media, no doubt promoting the good work that they did. And there it was, outside of the house, the very same exhibit which they brought into court and said it was found on a clothes basket, is outside in the bush being filmed. Right? So in such a case, the magistrate was not satisfied that possession in that item existed at all.
Yeah.
So the deeming provision didn't kick in those circumstances.
And it's very interesting, and sometimes, social media can work for you or against you. Yes. And obviously it forms part of evidence.
That's right. No, that's right.
Particularly when you still, yes, you have charged someone, you successfully stated that you read it, but then it still has to go through the judicial process.
No, that's right. That's why I'm saying it's fortunate, because of it came off their official Facebook page. Right. We got these videos. We put it in. The relevance was apparent immediately. but they did not challenge the authenticity. The video was highly edited, but by them.
Yeah.
So apart from the video being of grave concern, the fact that it was never disclosed, the fact that the whole unedited, the magistrate expressed grave consternation to that as well, right? So that, as I was saying, so they were fortunate that we were able to get that, and they didn't, and even though my guy gave evidence, it was clear that he didn't have to, because they did not discharge their burden of possession. Because once you're deemed to be in possession, once there's possession, then you're deemed to know it's there. So they were got off.
So this is, I mean, so obviously this is not only about the actual item or illegal, illicit item, but it's also about even at trial, getting into the mind of an individual to understand, because this more seems as though it's a psychological
well, yes, no, it can be because
sort
I
of
mean,
matter.
Yeah, no, I've done cases where the person is not saying that the items weren't found there, you know.
Yeah.
They're saying, but it's a setup by persons other than the police. They've set me up. This is upstanding citizens that have nothing but have little other civil matters going on. And it speaks to us clear setup. But nonetheless, because it's the issue of whether it's there or not is not in dispute, because they're saying, yeah, the police really find it there.
Yeah.
They still have to go into that box and discharge their burden and give evidence and hope the court comes down on their side with respect to on a balance of probabilities that it was there, but it was not there with their knowledge and consent.
Is this the only legal construct that the burden shifts from beyond a reasonable doubt to balance of probability in criminal cases?
In criminal cases, I can't tell offhand, but I don't think it is.
Right.
I don't think it is. I know in other pieces of legislation, certainly I'm doing one involving tax. There's a reversal of the burden as well. So it's not. I mean, even this was challenged constitutionally. A constitutional challenge was mounted on this reverse burden.
Yeah.
I think in the case of Dial Mirage, but it was dealt with. And they say no, the proportionality test is met. That a person are called upon, because remember it's a mischief, right? You don't want to have persons who have a room full of drugs, and you can't arrest them because they wasn't home at the time, right? It has to be that, and that's what the deeming provision seeks to circumvent.
Yeah.
Otherwise, I could just put a room, pull it up, put drugs on it, it's never ever be in the room. But if it is that the court can show that, and this is what happens sometimes, persons rent places, and it's for nefarious purposes. They're not there, but bus comes on, police is able to show that the lease is in their name, surveillance show that they came to there, not regularly, but enough. And a construct of constructive possession is that they have an element of control over that property,
Yeah.
right? And so therefore they can be charged, and once the evidence is there to support it, once the court finds it in constructive possession, well then, that's it, all right?
What about if someone is visiting a premises, let's say for instance, let's say Airbnbs. There's a listed owner, you have the Airbnb, somehow the owner, there were drugs in there, but the owner did not know because he had a tenant, well not a tenant, but a visitor there. And then at the time of the bust, the owner is charged because he has now been in possession of the property.
Right, yeah, so well, of course, that's the danger, but he'll be able to show that I give up my element of control when persons come in. This is what I do. I rent it as an Airbnb, right? I certainly give up. And if there's doubt in respect to that person will get off.
Yeah.
So, for instance, in Kidby Sessa and Gabriel Diosaran, Gabriel Diosaran lived upstairs, Kidby Sessa downstairs, police bust down, boxes full of marijuana. Diosaran at the time was downstairs, right? Police bust down. He says, I know nothing about these things. I live upstairs. You can come and check my place. He was convicted, but on appeal, it was overturned because his presence there was just a mere presence. They didn't have anything additional to show that those boxes there, he had any element of control over it because he had leased the property to the other person. And he had indicated to the police, I don't know about it. You can come and check my place upstairs. They went and checked and there was nothing. And so that was overturned on appeal. right? So, and it's always fact specific with respect to the courts and how they view the evidence.
And
right?
in a case like that, because I mean, you are on appeal. I mean, I'm assuming that these particular offences are available.
Yes.
Right.
Yes.
But is it that when your appeal is overturned, you cannot put forward a case of a malicious prosecution?
If the circumstances speak to it, like the one I just told you about the police video, yes. But if not, for instance, you know, if it's just a sheer matter of police incompetence, there's really no malice, there's incompetence. Right. And there's authority to say that incompetence does not substitute for malice, it's not interchangeable. And so if they just didn't do a good job investigating, there was never any surveillance to see that, well then you can't necessarily bring a case for malicious prosecution. But in a lot of circumstances, there are good grounds for it.
Yep. Do we have a element of joint possession in terms of our jurisdiction? What is joint possession versus constructive possession?
Well, it might speak to one and the same in the sense that if we were to bust down on a room, and in the room there's loose material, loose plant-like material on a center table, everybody get in charge. Now, we may be charged jointly, but of course the evidence is against each person to show. The evidence is clearly going to be the same. I went into the room, I saw defendant number 1, saw defendant number 2, saw defendant number 3, 4. In the middle was plant-like material resembling whatever. So it will seem the evidence in those cases will speak to everybody being in sort of actual possession of the drugs, because it's right there, it's in everybody's physical control. And it's going to be hard for you to say, well, unless you're blind, literally, to say that, well, I didn't know it was there, and it wasn't there with my knowledge and no consent, all right? Now, sometimes you can have a sort of gray area, which I've had before, in that you, for instance, you're in a vehicle, and boyfriend and girlfriend, boyfriend stopped to buy drugs. Didn't forecast that he was going to do that, didn't alert. So there was no time or opportunity to say, okay, yeah, go ahead, let's do it. I know you're going to buy drugs, that's fine with me. There's no opportunity to do that, all right? So in those circumstances now, the police bust down shortly afterwards and charge and say, look, we saw you all stop to buy out, right? It would seem that you would have to say, look, he stopped to buy, but I didn't know, and he didn't do it with my consent, and I certainly didn't know he was going to buy drugs. And that will be tested on the facts for the jury, meaning a magistrate sitting as both judge and jury, or if it goes to the High Court.
Or a good girlfriend may say, well, you know what, we go down together.
I'm sure it happens.
John, so the case, all right, so when someone is charged for possession of drugs, let's say drugs, ammunition, the charge is possession, it's not constructive possession.
No.
Is it?
No.
Constructive possession is the element that has to be proven.
Yeah, if it is, it wasn't on them.
Right.
So I say possession could actually be actual or constructive.
Right.
If they wasn't there at the time, meaning that it was found in their room and they weren't there at the time, they're not going to escape the charge, because it would, hopefully the prosecution can show that the person, in addition to being the occupier in the legal sense, they will have exercised an element of possession and control over that room. And therefore, that's why we charge them, right? I say difficulties if you can't prove that. Yeah. But sometimes, and this is where we bring a malpros, is that the prosecution never had any evidence that you were an occupier in the legal sense. And they never had additional evidence to suggest that. Nevertheless, they go ahead and charge you.
Yeah, and does that impact on sentencing in terms of whether someone is guilty of actual possession or
No, it's the same. It's just two different types of possession, but generally speaking, I mean, actual possession, you're going to have a lesser amount on you if it's on your person, as opposed to, so the constructive possession cases is generally larger quantities of drugs and stuff like that. I mean, man, you could have a boat, it could be in your home, right there, next to your bed table, in a drawer, you know. Something that really could reach in your physical grip, really, so to speak. But nevertheless, it's in a place that you occupy.
I'm happy that you came to give that appreciation because many persons obviously, wonder in terms of, okay, why if things are not in my, or legal illicit items are not in my possession, why am I still being arrested or whatever the case is? But of course, the police has to do their duty, and as defense attorneys, you also have a duty.
That's right.
So I think that this has been a really good session. Unfortunately, our time is up.
Thank you so much.
Yes,
for having
unfortunately.
Me. Privilege is mine.
Yes, thank you so much, John Heath. Of course, we were discussing the Dragnet in terms of constructive possession as well as felony murder.
Yes.
And I appreciate your time on this program.
Sure.
Thank you so
mine.
much. So guys, it's a wrap. Of course, I hope that you enjoyed this particular edition of Strictly Legal. My name is Rondell Donawa, and before I go, I leave you with this light quote. Do not judge me by my success. Judge me by how many times I fell down and got back up again. Nelson Mandela. So have a great week ahead, and God bless. Take care.